Thank you, Your Honor. May it please the court, Mr. Bradsher. First of all, thank you for being with us and bearing with us, more importantly, and keeping an open mind up until this point. And I'm confident, as I'm sure Mr. Bradsher is, that you all listened closely and took notes that would assist you in your deliberations and recalling the evidence in the case. And I'll start with that, in that if I say something or Mr. Bradsher said something that you recall differently, obviously you're the ones that get to decide the facts in the case. So remember it as you remember it, and you guys can get to talk about all of that, and you ultimately get to decide what the facts in the case are. One thing that I started this trial out with in opening statements to you all was that this is a case about public trust, about public funds, and the misuse of those two things by this defendant, Wallace Bradsher. That hasn't changed. That's still what this is all about, no matter what the defendant wants you to think it's about. Now, over the last week or so, we talked a lot to witnesses. Some of those witnesses were a couple of days worth of testimony. Some of them were shorter. Okay. But what I want you to think about, and what I want you to be thinking about when you're in this deliberation, is what is the real reason that we're here? Or what are the real reasons that we're here? Not 90% of what was talked about on cross-examination. Now, what the defendant is trying to do, and what he has tried to do over the last week or so, is, for lack of a better term, try to create a counter-narrative or a false narrative. This isn't anything new. This has been going on for years. The, hey, look over here, don't look over here defense. Okay? That's what you're dealing with in this case. It's a sleight of hand maneuver to say, look, don't pay attention to the important things, and it's very important, I would submit to you, that you do focus in this. And if you were listening in opening statements and just now in closing arguments, what did the defendant tell you that validates this issue that he's trying to create a counter-narrative? Well, he told you a lot of things, but specifically on point, he said, this isn't a case about the dates that I'm charged with. This is a case about other things. Well, that's not what this is. This is a case about the dates that you're charged with. This is a case about the things that brought you here. This isn't a referendum on whether he worked hard, or whether Pam Bradsher worked hard, or whether his office was hardworking and did the best that they could. No, that's not what this is about. What this is about is the fact that he did not require an employee to do work, and he allowed her to get paid for that work. And not only did he allow it, he was complicit in it. Now I'm going to go through and I'm going to talk to you at length, try not to be too lengthy, but at length about what the evidence in this case I think shows, and how it shows and how it applies to the law. And we'll go through later on in this presentation what the elements of the crimes are, because as we talked, if you remember, all crimes are made up of elements like cakes. We had that discussion. If you've got all these things, then you get the crime. All right? But I want to talk about this counter-narrative so we can get that out of the way and really focus on what the issues in the case are. Now, when you're creating a counter-narrative, as I've come to find out, there are a couple of things that you want to do. One is you redefine the investigation. Okay? Put everything else on trial than what's really on trial. Is there evidence that that's what's occurred in this trial? Well, we talked an awful lot about this nursing school and who was an indexed subject where, and at the end of the day, Does that have anything to do whether Wallace Bradsher was an index subject at the beginning of the day when the FBI starts investigating this crime as to whether or not the defendant allowed Cindy Blitzer to work and get paid, or not work and get paid? No, it doesn't. The fact remains, if Cindy Blitzer did this and the defendant knew it, it doesn't matter what the FBI thought on day one when they walked in there, okay? The other thing that you try to do, and this is a crazy word, I think, but whataboutism, right? Well, what about this, and what about that, and what about this other thing? And well, in this case specifically, well, what about this school that, these tests that were taken? How much testimony did you hear from the defendant's cross-examination about these tests that were taken? Now, to be sure, I don't think that's something that you should ignore. It's certainly something that you should consider in deciding whether you think someone's credible or not. But is that why we're here? Is that why we needed a day and a half of cross-examination on that issue? I'd submit to you, no, it's hiding the ball, okay? As I said, you redefine the investigation, you attempt to delegitimize the investigation, okay? And what are you doing? That's what the whataboutisms are. That's what the finger pointing is. That's what the, hey, don't look at what I did. Look at what these other people were doing. And as I said, this isn't anything new. There's an old quote from a philosopher, and it says, to justify himself, each relies on the other's crimes. Okay? What have you heard in this trial? The defendant is trying to justify his actions by just saying, hey, don't worry about what I did. Look at all the terrible things that they did. Look at all the terrible things that Cindy and Craig Blitzer did. And I'm not going to stand here and tell you that Cindy and Craig Blitzer are wonderful people, that they did a wonderful job, that you should believe every single thing that comes out of their mouth. Because quite frankly, I would submit to you, you shouldn't believe every single thing that comes out of anybody's mouth. You're the people who get to decide what, if any, credibility a witness has. Okay? And the judge is going to talk to you about that. He's going to give you an instruction about that. And his instruction is going to say you can believe all, some, or part of what a witness tells you. He's also going to tell you that when you hear from a testifying co-defendant like Craig Blitzer, that you should consider them and you should be skeptical of the things that they say. But if you find and if you believe what they're telling you to be true, treat it just like you would anybody else. Okay. And we talked about that in jury selection, about not starting out behind the 8-ball. And I think some of you said, yes, I would view them skeptically, but I would also listen to what they have to say, and if what they say makes sense, then I would follow that. And I would submit to you that's still where you should be, okay? Think about what these people are telling you, judge it with the other credible evidence in the case, and make a decision if you believe them or not. Now, the other thing, one thing I want to talk to you about as well is, and it was a big point that the defendant tried to raise on in his closing arguments, what motive does Craig Blitzer have? Did Wallace Bradsher have in this case, okay? What motive does Wallace Bradsher have to just kind of say, whatever, if you don't want to work, don't work, I'll still pay you. And he wants you to believe he has zero motive, okay? But is that really true? When you really look at the evidence in the case that you heard, is that really true? He had nothing to gain from this situation? I'd submit to you that it's not. What motive does he have in this situation? Well, I would submit to you there's quite a few things that he has as far as a motive in this case. One, if you go all the way back to day one, his motive is, I got my wife, she's working, now she can't work for me anymore. Got to get my wife a job so that she can continue to do and be a part. It's this temporary fix until we can sort out this whole ethics commission thing, and then I'll get her back and we'll be back to our great team of saving the counties. Again, not saying they didn't do a good job when they were working, when they were trying cases. That's not what this is about. But when you're looking at the motive in this, is that the only motive? Wallace Bradsher gave you a motive as well. What motive did he give you? He stands before you and says, if I have any flaws, it's that I think I can solve every problem. What's the evidence in this case show? He was trying to solve every problem. Does he feel bad that he couldn't solve the problem for Cindy Blitzer when he said, I'll get you into PCC, and then it works out that she can't get into PCC? Maybe. Is there a financial gain for the defendant in this case? Maybe not personally, but you've heard through the testimony how important his office was to him, right? What did his office gain from this? And you learned a lot of this through Tyler Henderson, okay? This Iraq war vet that the defendant vouches for, basically in his cross-examination and in his closing argument to you. Well, what do you learn from Tyler Henderson that causes you to believe that there may be some motive for the defendant in this case? Well, one, you learn that Tyler Henderson, while technically employed by Rockingham County, isn't working in Rockingham County. He's back over here in Person and Caswell County. And not only is he back over here in Person and Caswell County, he's in Person and Caswell County with a pay raise. Why is that important? Well, that's important not because Tyler Henderson maybe doesn't deserve the money, but what is important is that if you remember the testimony from a prior witness, I believe Ms. Tant, there was this discussion about allocations. And at the time that Craig Blitzer agrees, I'll use that term loosely, to hire Tyler Henderson, Wallace Bradsher could not give Tyler Henderson any more money because his allotment was at zero. So Tyler Henderson gets a pay raise. He's back. What does that do? That frees up another spot, as you heard, in Wallace Bradsher's office. So what does he do? He hires another person. And he's back. He's got two people now back in his office, and he's only got to pay this one. He's got Cindy over here doing whatever Cindy's doing. He's not worried about it. Go to nursing school, it's fine. He does have financial incentive in this case through his office. There is motive in this case. Now, we spend a lot of time on motive, but one thing that will be should be conspicuous to you when the judge reads you the law in this case, you're not going to hear anything about motive because motive is not required. What's required is, did X, Y, and Z occur? If X, Y, and Z occurred, then the answer is guilty. If X, Y, and Z did not, then the answer is not guilty. Or if there's a reasonable doubt as to one of those. You will not hear motive come out of the judge's mouth. Sure, it's helpful in determining whether something occurred, but it's not required. So you've got motive in this case. And quite frankly, if you take the defendant at his word wholly, you got even more motive. Because then he's got Cindy Blitzer working for him. He's got, at one period, Pam Bradsher back working for him. Curiously, I would submit, she's transferred because of this whole ethics thing, but then two witnesses tell you within a month of that, 2 months of that, she's already back over there working for him on their work, not Rockingham County work, mind you. He's got Tyler Henderson, and he's got this third employee that he's hired as a result of the Tyler Henderson move. So he's at extra staff at that point. And when he read you that list, or the explanation about why his wife deserved all that money, what was in that? We have never fully recovered from the loss of staff members. So there's motive. Now, we talked about credibility, and this case boils down to it, quite frankly. It boils down to essentially a couple of people's credibility, I would submit to you. One, Craig and Cindy Blitzer. Do you believe them? Do you disbelieve them? And again, it goes back to this credibility issue of, well, sure. Did they have something to hide? Initially, yeah. Did they lawyer up? They sure did. Did they do the right thing in lawyering up? It would appear so. Because Cindy Blitzer didn't get charged. I'm not going to stand here and tell you that that's right. It may not be right. but it's what happened, okay? But what did they really gain? That's all they gain out of all of this. Because if you really think about it, if what they're telling you is a lie, then in reality, Wallace Bradsher's not the dumbest crook in the world. They are. Because all they had to do is stick to the script. When Wallace Bradsher calls them up and says, hey, remember, you're working on those special projects, wink, wink, hint, hint. All they got to do when the SBI comes around and say, no, I was working on special projects. I worked at night, did everything. You know, I did everything. I would come in at night, I'd log it. Those 8 hours, those are legit 8 hours. That's not what they did. They said, I knew what I was doing was wrong. I kept doing it. I owned up to it eventually. And now I'm trying to make it right. And when he tried to get us to compound the issue by lying about it again to the SBI, we didn't do it. But who did do it? Who was untruthful with the SBI? I would submit to you it's the defendant. And we'll talk about that in just a few moments. Motives that were given to you to not believe Craig and Cindy Blitzer. And quite frankly, I would submit to you this goes to a reason why you should believe them. If what they are saying now is a lie, why would they come in this courtroom and be dragged through the mud the way they were? Craig Blitzer's mental health dragged through the mud. He's suicidal. The allegations of that. Why submit yourself to that? The marital problems at home with this balloon payment. Why submit yourself to that stuff coming out in this circumstance? Craig Blitzer didn't get away with this thing scot-free. He pled guilty. He lost his law license. He paid back $50,000. What evidence did you hear that the defendant did anything to mitigate this? Zero. In fact, all the evidence that you hear is that the defendant did things to compound, to build upon the deceit and the hide-the-ball strategy that he's tried to employ in this trial. He tried to employ it in those other trials, or in the investigation in this case, okay? So, what evidence do you have to believe Craig and Cindy Blitzer? The defendant wants you to, he essentially talks to you out of both sides of his mouth when he talks to you about Cindy Blitzer's work, right? He stands here and he, at one breath, says, well, he didn't prove to you that she wasn't working. Then he says, and that's when it benefits him. When it doesn't benefit him, Cindy Blitzer wasn't working and I didn't know about it. Well, which is it? You can't have it both ways. And he wants you to say, well, there's no evidence that Cindy Blitzer was working other than her word. Just take her at her word. There's this mysterious computer that shows that maybe she was working, maybe it doesn't. But she tells us, so we all stop. Was that really true? Is there evidence that Cindy Blitzer wasn't working? One, why would you lie about it if you were? You just say I was working. Two, there's verifiable evidence that during the days for months she's at nursing school. The SBI agents told you. We sat and watched her car pull into the parking lot. We watched her get out multiple times a day during working hours. She says, I never did anything. The defendant never gave me anything after they took that file from me. Jay Stoltz, who has been put on a pedestal by the defendant, he even told you he's believable, but then again wants you to disbelieve him when it comes to the bad things that Jay Stoltz says about the defendant, and we'll talk about that in a minute. But Jay Stoltz says, I gave her one case, really. After that, I never gave her anything again. Never saw or heard of any work that the defendant gave her. All of this is evidence that corroborates the fact that Cindy Blitzer wasn't working. And I can't believe that we have to stand here and tell you now that Cindy Blitzer wasn't working and that he's contesting that fact. But it seems incongruent with his defense to stand here now and say, well, maybe she was working, when his whole defense has been, I wasn't supervising her, how would I know? Now, what other evidence do you have that makes Craig and Cindy believable? Independent, verifiable evidence. I would submit to you telephone records. They tell you about this phone call. They're very specific. And sure, she gives the wrong phone number to the SBI. I'm not going to defend that. But what I will say is when she was asked on cross-examination, what's her phone number, was she able to give it to you? She said, I don't remember what it was at that time. We changed our phone. I don't know what the number was. But the evidence is clear, I would submit to you, that that phone number that ended in 76 was their home phone number. The only question about that was that Agent Whitley flubbed it a little bit when he was asked about it by the defendant, but that was clarified. He said, I went back, I looked at it, I was wrong, he owned up to his mistakes. And that goes to Agent Whitley's credibility, okay? Which has also been impugned by the defendant, putting the system on trial instead of himself. Agent Whitley, you saw him testify. Is he trying to frame anybody in this case? I would submit to you, Agent Whitley isn't framing anybody, okay? You heard the testimony. Now, the other things, and I was talking a little bit about what we learned from Tyler Henderson's testimony. You learn three other things that I would submit to you are important through Tyler Henderson's testimony. One of those is that what I'm going to refer to as the puppet master, okay? The puppet master in this case is sitting right over there. You heard Craig, you heard Cindy. Sure, not good. They did what they did. But does it really seem like that was their idea? Or does that seem like that was the defendant's idea? The whole wife swap in general. Craig Blitzer says, I get this call or the email, I send it to Wallace. Wallace, even on cross-examination, tends to say, well, we had this conversation, didn't we? And I called you, and I did this, and I took the lead to go through and do all these things. Isn't that correct? Absolutely. Verifiable? It's verifiable through those emails that were sent from the Ethics Commission that sent them back to Wallace Bradsher, where Wallace Bradsher's trying to come up with an idea to do this job switch. Craig Blitzer's been on the job 10 days or so. Wallace Bradsher's been on the job for 4 years at this point. Is it reasonable to believe that Craig Blitzer would say, well, Wallace Bradsher seems to know what's going on. He's been a DA for 4 years. I just now got the gig. Sure, I would submit to you that's reasonable. How do we learn more of this puppet, that is consistent? What is there to corroborate that? What there is to corroborate that, I would submit to you, is the second step in the puppet master moves by the defendant. He's playing with the marionettes, and that happens when his wife resigns. He calls Craig Blitzer and says, hire Tyler Henderson. Did you hire anybody yet? You need to hire Tyler Henderson. He pushes back on that a little bit and says, well, why don't I hire somebody and I'll just loan them back to you and we can... No, you need to hire Tyler Henderson. I want Tyler Henderson to be hired. Why is that so important to the defendant? Craig Blitzer goes along, hires him. Craig Blitzer says, I don't really know what Tyler Henderson was doing. He never worked for me. He was always back over working for the defendant. How do we verify that Craig Blitzer's telling the truth about that? Tyler Henderson told you. I never worked over there. I went over there like 4 times. So, he wants you to believe one part of the witness over here, but in the same, and build them up to be this honest, trustworthy person, and then in the same breath tears them down and says, wait, no, you can't believe them when it's bad against me. Okay? Incongruent. And what I would submit to you is that all of that goes to the defendant's credibility with you. Okay? The other thing that we learn is that there was no real employee share program as he wants you to believe. How do we learn that? Well, quite frankly, sharing needs to involve 2 people, right? 2 people ought to get some benefit out of the deal. What benefit does, if this is a legitimate job share, what benefit does Craig Blitzer get out of that deal? Well, I'd submit to you none. Wallace Bradsher got all the employees if it's a legitimate job share. He gets Ashley Ferguson, he gets Tyler Henderson, he gets Cindy, he even gets Pam. Because Pam, even though she's working, and I'm not going to dispute that, I do dispute who she was working for. On paper, sure, she's working for Rockingham County, but Wallace Bradsher's own employees are telling you That ain't the case after about a month. She's back over there working for him, skirting the ethics rule again. An ethics rule that he now tells you he understands why. It's to protect us against Craig and Cindy Blitzer. All the evidence in the case would suggest to you that the only people that are really trying to skirt that ethics rule is the defendant. The last thing that we get out of Tyler Henderson that I would submit to you that is very important is that Wallace Bradsher knows the correct procedure for having an employee go to school. What do I mean by that? There was an email presented that says, hey, Tyler Henderson's going to law school. We're going to reduce his hours to 20 hours a week. No email like that is sent for Cindy Blitzer. None. So he knows how to do it, he just doesn't do it. Gail Peed, she tells you, she doesn't mince words much. What does she tell you? She says, Pam was back working for us, Tyler was working for us, we didn't lose anything out of that deal. So all of this goes to credibility, this also goes to motive, okay? Now, Wallace Bradsher wants you to throw the book at Craig and Cindy Blitzer and give him the benefit of the doubt that he made mistakes. They were not criminal mistakes, but he made mistakes. He didn't tell that to anybody until he comes in here in closing arguments and admits to you that he's made mistakes. He didn't tell that to law enforcement when they're investigating. In fact, when law enforcement's investigating it, what's he say? Nope, she's working. When Jay Stoltz comes by and says, hey, is everything still the same? Is she still working? Absolutely, she's working. Put those hours in. Not, this is a failure on my part. No, it's cover my backside, clear these hours, and get me out of here. Get me out from under the thumb of the SBI. So, he wants you to dispel any belief of what Craig and Cindy Blitzer tell you as the truth. But look at the reality of the situation. Who got in bed with Craig and Cindy Blitzer on day one of this whole thing? Birds of a feather, right? If they're terrible people, he's right there with them. The defendant chose his partners in crime when he sat down with those people and made this deal. Now he's mad about the fact that he couldn't trust the other criminals that he worked with. Okay? That's the reality of the situation. Now that they've turned on him, it's bad. When everybody was working against the state, it was fine. So, what I wanted to, another thing that goes to credibility for Craig Blitzer that the defendant tried to make a big deal out of, I think, is this WTF email. And then this question about, what did you say? There was some other email or statement to one of the test takers. Do you remember telling him to keep his effing mouth shut? And there's this email that says, WTF, the lawyer told him talk or don't talk. You don't have to talk. WTF. Where else did you hear that phrase WTF in this trial? There was one very important time that you heard it, I would submit to you. And it's during that October telephone call that Craig and Cindy Blitzer are talking about when they call him to resign. And they say they're on the phone and the defendant starts talking about special projects that nobody's heard about, I'd submit to you from the evidence, until after the SBI comes knocking. And what do they say? They say, we're looking at each other through the glass door and he goes, I don't know what these programs are. WTF in an email, WTF in that conversation. Is that credibility? I'd submit to you it's consistent. That's the defendant's evidence and our evidence consistent with each other on one fact. And that's that Craig Blitzer was being truthful about the fact that the defendant knew she did not need to work. So that talks about motive, and the next big thing that I think is an issue is knowledge. And knowledge is important in this case because the defendant wants you to believe that he had no knowledge that this was going on. So let's look at the facts of the circumstances and ask yourself, is it reasonable that he didn't have any knowledge that this was going on? He's told about nursing school and the possibility in Elizabeth's Pizza at this clandestine meeting of the wife swap. Okay? So he knows about that. He knows that she no longer needs just one class because the testimony is he's tried to get her in PCC, which is the only way that she's going to be able to have this one class thing, and that doesn't work out. And everybody has testified that everybody knows if you don't get that exemption in that case, you're going to have to go back and take a bunch of classes over. This was important, I would submit to you, that in 2005, Wallace Bradsher takes over the duties of Caswell County as the chief. Now, why is that important? Because the only reason that Jay Stultz was in charge of Cindy Blitzer, and I'll talk about that in just a second, why that's a bit odd, and I would submit to you as evidence tending to show this conspiracy, is that the only reason Jay was in charge was because he was in Caswell County, which was closer to Rockingham, and they had this case. All the evidence is that case is gone from Jay's hands at that point, and Jay's no longer in Rockingham County. Jay's told you that at least on 3 occasions he talked to the defendant about him not having the responsibilities of supervising Cindy Blitzer, and that Cindy Blitzer, and Wallace Bradsher says, don't worry, she's not in your chain of command anymore. On another case says, I'll take care of it, I'll reassign them, I'll reassign her supervision, I know you've got a lot going on. He's in Rockingham County, he's in Caswell County, and he's the one in charge of that county, and he's not sending any jobs to her at that point because there's no evidence. Remember that. Evidence comes from the witness stand, not from his mouth as a question, okay? Or as an argument. Evidence is the answers, not the questions. There's no evidence that she was assigned any job post-Shockley. That's uncontroverted evidence in this case. Jay says it, Cindy says it, they all have said it. Craig says it too. Now on that issue about why was Jay assigned this job, does that make sense to you that Jay would be assigned to supervise this one person, and the innuendo or the insinuation is that, well, that was because Gail Pete, who supervises everybody else in the office, wasn't going to keep an eye on her. Well, Gail Pete testified, I supervise people in 2 different counties every day, and I don't see those people every day. So, ask yourself if that makes sense. Does he know about this? Well, he tells her to vary her hours. Make it look like you're taking time off. Don't just put in straight 8s. He's told by Craig in April, my wife doesn't have anything to do. Give her some work. Focus on school. Is that consistent with the other things that we know? We know he knows she's going to school. We know at this point he should know she doesn't have any work. Craig is now telling him doesn't have any work. He says, tell her to focus on her school. Right there, there's an agreement. And we're going to talk about this, about what it takes to cause a conspiracy. All a conspiracy is that an agreement between 2 people to commit a crime with the intent to have that crime carried out. Okay? Is there an agreement here? Is it? And a conspiracy doesn't have to be a verbal agreement. Okay? Conspiracy could be a tacit agreement. You know, and you continue to let it happen, and you've acted, you entice it, you're okay with it. You don't have to say yes, okay? I would submit to you. Now, is told by Craig in March and April, focus on, or that she doesn't have work. He says focus on school. Multiple conversations with Jay about not having supervision roles. Cindy testifies, I keep calling him, he won't call me back. Then you get to this conversation in October. The conversation in October is very important. And I talked to you about why you should have believed that a moment ago when I said that WTF thing and the phone records that verify that this phone call happens. But in that conversation, when they say, I don't have anything to do, he doesn't say, well, what in the world have you been doing for the last year? He says, you haven't done anything wrong, unfettered discretion, I can do with you what I want to do. I'd submit to you that goes back to motive as well. Defendant thinks he's the big man in town. He's the elected district attorney. I have unfettered discretion. How many times did you hear that? I'm the hiring authority. I am the firing. The ultimate employment decisions rest with the elected DA. He's the cock of the walk. He's the big man in town, right? He's walking around, and what it boils down to is hubris. He thought he was too big to fail. Okay? The government's never going to come after one of their own. I can do what I want with impunity, and it's okay because I'm the DA. Ladies and gentlemen, that's not the way it works. Okay? Intent is an important element when you start talking about the elements of crime. You're going to hear intentionally or willfully. And I want you to focus on that because intent is something that's seldom provable by direct evidence, because it's kind of like we were talking about in jury selection. You got to get in somebody's mind. And there's really no way to do that other than to look at them and see what they've done and make reasonable inferences about what someone has done and what they knew, right? You do it every day in your life. And so when you're doing that, and this is why some of these facts are important about the pizza restaurant and vary the hours and focus on school, because you need to look at the defendant's actions before, during, and after. And that's going to help you to get in his mind, to see what did he know? What was he really agreeing to? Did he know what was going on? And when we've talked about before, but let's look during. He continues to pay her, even after, or to allow her to be paid, even after the SBI lets him know. Hubris. He continues to not give her tasks. No evidence that she was given any other tasks after that's taken. He encourages her to go to nursing school and focus on her car ride. Encourages her tacitly by going and trying to get her into a nursing program. And encourages her vocally by saying to her husband, tell her to focus on school. It's cool. We'll take care of the rest. And then after, he's untruthful with the SBI when they come knocking. He says she's working on these special projects, which by this time we should all, I would submit to you, agree there were no special projects. He, frankly, is very dishonest when he just says, yeah, she's working. Because if you are to believe the defendant's story, is that the response that you give when somebody says, hey, we're looking into the fact of whether Cindy Blitzer's working? You say, well, dang, I thought she was working. I think she's working. I'm pretty sure she's working. She should be working. That's not what anybody has told you that the defendant said. And he didn't even ask the questions to say, well, didn't I maybe cast a little doubt on it? No. The affirmative answers were given. She's working. Yeah, she's working. Those untrue statements go to his state of mind. Okay? The fact that he tells the SBI this story about special prosecutions, and he tells Craig and Cindy Blitzer on that telephone call this conversation about special projects. Gail Peed, special projects. I asked her, well, where did you hear that term? The defendant. Did you ever see any? I didn't know what he was talking about, but I know he said that phrase sometime. The only inference of a special project was posed to Craig Blitzer, and it was mental health court and DWI programs, and he shot both of those down. And I would submit to you those are believable answers when he says to you, people in my county weren't going for a DWI diversion program, okay? None of it had anything to do with Cindy. Maybe those programs exist, but Cindy wasn't working on them, I'd submit to you. And then this causing of the falsification of documents to Jay Stultz. Jay Stultz told you, I get this call, I show up. He says, hey, there's an investigation into whether Cindy's working or not. And I think, oh my God, I've screwed up. I can approve the time. If that's what it is, maybe that'll fix it. And Wallace Bradsher says, you can do that? He says, yeah. So he goes in the room and he was detailed. I sit down, I'm in the conference room, he's over there, and I holler to him. Is everything the same with this employee share thing? Yep. She's working the hours? Yep. And I said, was that an affirmative answer? He said, yes. He said yes. Now, this goes back to that last statement I was making about the SBI and there's no waffling in the defendant's answers to them about whether she's working. Okay? And ask yourself what a reasonable person would have done in that circumstance. And if it's not reasonable, his reaction, then I would submit to you, then that's evidence of his intent. When he's asked that question, or when he poses this issue to Jay, Jay says, well, who's approving her time? Wallace says to Jay, you are. Jay says, no, I'm not. Remember those 3 or 4 or 5 conversations we had about me not approving her time? He says, well, let me call Gail. I call Gail and I say, are you approving her time? No, I thought you were. I don't know. Gail told you about that? Jay told you about that. Then he asks him, after this disagreement about who's approving the time, Jay says, is she working these hours? What does he not say to Jay at that point? He does not say, hell, I thought she was. I thought you were supervisor. How am I supposed to know? Golly, I mean, you're the supervisor, not me. No. His response is yes. And as soon as Jay comes back out and says, hey, boss, I approved those hours, what does Jay tell you that he says to him? Okay, got to call Craig. Jay Stultz, he wants you to believe, would not lie. So is he lying when he says all these things about Wallace Bradsher? Both sides of your mouth for the defendant. I would submit to you that he's not. So now, what I want to talk to you about are the elements of the crime. And we talked about conspiracy, felonious conspiracy. The defendant, Wallace Bradsher, with Craig and or Cindy, enter into an agreement. That's important. And you don't have to write all these down unless you want to. The judge is going to give you the instructions. I just want to talk to you briefly about them, okay? Craig and or Cindy make an agreement. The defendant made a big deal about that with somebody on cross-examination. Oh, I think it was Cindy. I never spoke to you. I always spoke to Craig, didn't I? Is he trying to insulate himself, hide the ball? The agreement is to commit a crime, and in this case, that's obtaining property by false pretenses. Did they make that agreement? I think it's pretty clear that Craig and Cindy Blitzer committed obtaining property by false pretenses. They fraudulently got paid for things they didn't do. So the question for you becomes, did the defendant agree to it? They intended for the crime to be carried out. Okay? So, what I say? It's an agreement to commit a crime. And is there evidence sufficient to you to believe that the defendant knew and was in agreement with Craig and Cindy Blitzer submitting false timesheets and receiving, this is important, the question, the issue was raised to you about, well, was this issue about if you don't put time in Beacon, you still get paid. But if you'll remember, there was also testimony that if you don't put the time in and get it approved and released, then you don't get your benefits. And the charges here are that not only that she got money, she also got those benefits. And the evidence is clear. She got benefits. She told you and AOC told you. Obtaining property by false pretenses. The defendant makes a representation. Second, it was a false representation. Third, that representation intended to deceive someone or something, the thing being AOC or the state of North Carolina. And it did deceive. And they gain, and this is important because he wanted you to say this about the time, she didn't gain anything by the false representation or attempted to gain some property. And in this case, that's salary, benefits, sick leave, and medical insurance. Okay? Now, as we said, I think it's pretty clear, I would submit to you it's pretty clear that Craig and Cindy Blitzer committed this crime. I'd submit to you that. Okay? Here's where you may have an issue. That the defendant made a representation. I'm not going to stand here and tell you that Wallace Bradsher called up AOC initially and said, yeah, she's working. I would submit to you that he does make a representation by her continued employment and having his employees continue to release her time for a period of time to AOC. But the next step of this is where that's really solved when you start looking at the elements of a crime. And that's this theory of acting in concert. And what you'll find, and the judge will instruct you about, is that the defendant does not have to do all of the acts of obtaining property by false pretense. If he joins in a common purpose to commit the offense, I would submit to you he's joined in a common purpose with Craig and Cindy Blitzer for all the reasons we've already talked about, okay? And that the parties are actually or constructively, you don't even have to be there when the crime's occurring for you to be a part of it. And then the crime occurs. So if you find this solves the problem for that defendant making the representation, okay? This is a way, this is not a separate crime, acting in concert, okay? This is a theory that lets you prove the first crime of obtaining property by false pretenses, if that makes sense. You've got this crime and you've got to find a way to get, or there needs to be a way to show that that crime occurs. This is a way to show that the defendant was involved and is therefore equally as responsible as the other parties because he was equally as involved. Not even equally as involved, because he was involved. Okay? If you're involved in it, you're in it. It's the old adage that your parents probably used to tell you, be careful of the company you keep. Okay? So, as I said, guilty of the crime of obtaining property by false pretenses if you do this. So, you will have the opportunity to say guilty of that, obtaining property by false pretenses, or not guilty of that. And that's on that verdict sheet. Okay? No matter what you decide, guilty or not guilty, it would be your duty to move on to the next charge. The next charge is aiding and abetting a false pretense. This is, for your purposes, a separate thing for you to consider. And it's first that the crime of obtaining property by false pretenses was committed by someone. And in this case, Cindy and or Craig. Okay? And if you find that, you must find that the defendant advised, instigated, encouraged, or aided them to commit the crime. Did the defendant encourage? I would submit to you, yes. He says, tell her to focus on her school, not to worry about it. Did he instigate it? I don't know if he instigated it, but it doesn't have to instigate it, right? It's an or. Does he advise? I'd submit to you there's some evidence that he advised them of that by saying, tell her to go. He certainly aided it. And he aided it in a couple of different ways. He aided it, one, by not firing her when he figured out that she was not working and getting paid for it. He aided her with this environment that he created to allow it all to happen. He sets the ball rolling. He's a participant in the thing. And his action and or statement causes or contributed to the commission of the crime by that other person. Does what he did contribute to that ability of Craig and Cindy Blitzer to get paid without working? I'd submit to you the answer is yes. This is separate and apart from that conspiracy. This is separate and apart from the first obtaining property by false pretenses. If you find that Cindy committed the crime of obtaining property and that the defendant encouraged or aided her and that it contributed to her ability to commit that crime, then he's guilty of that. And I would submit to you the uncontroverted evidence in this case is that. There is zero evidence that that did not occur. All of the evidence would prove to you beyond a reasonable doubt, I would submit, that that did occur. The defendant knew about this, participated in it, and encouraged it. Then we're going to get into these obstruction of justice charges. And what I'm going to do is first lay out the three scenarios for obstruction of justice. And we'll go back and talk about what the elements of that is, okay? First one is that he fabricates evidence or provides false evidence to David Whitley, knew that he was investigating a fraud offense, and misled him during that September 6th meeting. So what are the false statements that he provides to him? One is that Cindy's working. He affirmatively says to her she's working, which is not true. And I would submit to you, based on all the aforementioned reasons, he knew it wasn't true when he said it to her. He does not say to him, I think she's working. He says, she's working. He makes up this story about special projects, which I would submit to you we've kind of debunked by this point, that nobody knows anything about special projects other than the defendant until after this meeting. And what we'll talk about is that this impedes or delays or obstructs an investigation. He knew they were looking into it because they told him they were looking into it, told him what they were looking into, and he creates this false narrative, much like he's done in this courtroom, to hide the ball from the SBI. Okay? And I'd submit to you, but for these, it's a shorter investigation. Okay? Two is that he gives false information to Jay Stultz, causing him to approve or transmit false beacon time. This is where the defendant, in his sole defense to this, in his argument to you, said, well, he didn't prove to you that it was false beacon time. But in every other argument, he said she wasn't working. Again, Jay Stultz is believable. Even the defendant tells you to believe him. An affirmative statement, yes, those beacon hours are good, she is working, transmit them. Let's call this what it is. We're calling it obstruction of justice. He's fabricating evidence on this case. Okay? He's not, because what is he doing again? The same thing he did with only talking to Craig Blitzer. He's insulating himself from the scenario just enough to say, so he can come in here today when he's called to task on it and say, well, I didn't approve the time. Jay Stultz approved the time. Jay Stultz told you and the defendant's exact quote in his closing argument was something to the effect of, I don't want to say exact quote, but his quote was something to the effect of, you saw Jay Stultz, and heard Jay Stultz. Does Jay Stultz look like the kind of man that would break the law to you? I submit to you, no, he doesn't, and no, he wouldn't if the defendant didn't tell him some stuff that wasn't true. Because by all accounts, this is breaking the law. And the defendant caused it to happen. And but for this, it's a shorter investigation because they don't have to track down all this stuff about, well, what's the deal with all this approved time and talk to AOC and do all this. That clearly hinders this investigation and certainly delays it. And the third one is the one that he wants to make a big deal about to you as well, which is the Debbie Hallbrook, Person County, that she was there and she was discharged in order to deter her and others from cooperation with the SBI. What evidence is there of this? Well, there's certainly evidence that she was fired. Gail Pete told you I was sitting in the office when it happened. There's evidence that it happened after she talked to the SBI. You know, when he talked to the SBI, you heard some testimony about, or when she talked to the SBI, you heard testimony of when she was fired. I would submit to you. And the other thing that I would submit to you about this is look at the facts and circumstances around what Craig Blitzer tells you about this conversation. He doesn't say, called me up and told me they fired her for that. Because maybe that wouldn't make. Why would he confess that if that is done? If he's doing it for this reason? But what he does do, and why he makes the confession is he's trying, much like that October telephone call where he creates that false narrative about the special projects that they won't go along with. He's trying to get Craig Blitzer to fire people too. We demand loyalty, absolute unfettered discretion. We can do what we want to do. Maybe it had something to do with, at least in part, with this digital discovery. But I would submit to you, based on that conversation and that context of unfettered discretion and demands of loyalty to his kingdom in Person and Caswell County, that it's believable that that's the real reason why he's fired her. He's hiding the ball. He doesn't want people to tell the real people to tell the truth about what's going on over there and that Cindy wasn't working. Now, the elements of those three charges for obstruction of justice is that the defendant doesn't act. Okay, we talked about what those acts were in each of those three. That either prevents, obstructs, impedes, or hinders the public and legal justice. It's a broad topic. What's the public justice? What's the public? What's legal justice? This is legal justice. An investigation is public justice. Public and judicial and legal justice. Is he delaying, obstructing, and impeding that by these three actions? He sure ain't making life easier on the SBI by these three actions, I would submit to you. And then that he acted unlawfully or willfully. Okay? It's not okay to fire people for those reasons. It's not okay to fabricate evidence. It's not okay to lie to the police. That's unlawful. He did it intentionally. He did it willfully. These are not mistakes that he's making. And you know that by looking at the totality of the circumstances here. And that he does it with the intent of deceit, the intent to defraud, in secret or with malice. Okay? He's not open and honest with people about what he's doing. He's being secretive. He's not telling Jay Stoltz, hey, these are bad times. Go in there and approve them. He's not telling the SBI. And in fact, he doesn't tell the SBI about that Jay Stoltz approval, does he? Jay Stoltz tells them about that August approval date. The defendant doesn't tell him. The defendant lets him go right on believing, hey, I didn't do it. Jay Stoltz did it. Wasn't me. The last charge I would submit to you is the charge that I would say, no matter what way you cut it, the defendant's guilty of something in this courtroom today. Okay? If you believe all those things that we talked about and why you should believe them, all those people, and you believe that he knew this was going on and that he was a party to what was going on and he encouraged it or aided it and abetted it, then he's guilty of all of those obtaining property by false pretense charges. Okay? If, and I would submit to you, you shouldn't believe this, but if you believe the defendant at his word, and as he stood here in this remorseful tone and told you I made mistakes, these are managerial mistakes, then he's guilty of this crime. And here's why, because these are the elements of this crime. That he was the sworn DA of that county, uncontroverted. Here's the oath of office. This is the oath that this breaks. And he's right, I'm going to talk to you about oaths because it's important. He swore to uphold the Constitution. He didn't do that in this case, okay? He said that he would be faithful and bear true allegiance to the state of North Carolina and the constitutional powers and authorities herein. He didn't. He lied to the SBI. He hid the ball at every occasion. He was untruthful. And I would submit to you that is important in this case. Okay? It's proved to you beyond a reasonable doubt that he was that person. He was the sworn DA. That during his employment he omitted, neglected, if you take him at his word, or refused. That's an or. One of those three, while he's in office. He clearly, by his own admissions, I would submit to you, neglected his office because he creates either knowingly and feloniously this environment, this den that allows this type of behavior to happen, or he neglectfully does it. He creates the circumstance that allows this whole thing to happen. And but for that action, these lies with the state don't pan out. And these people don't get the money. And so, what I would submit to you is that what has happened throughout this trial and the investigation is that the defendant has tried to pull the strings. Okay? Tried to pull the strings with AOC. He's tried to pull the strings with his office, the SBI, the Ethics Commission. He's tried to solve all those problems in his own way for his own gain. And if you want to believe him, it's the worst conspiracy theory ever because you've got about 18 people that have had to come in and talk, or agencies included, the media, AOC, SBI, the DA's office, all the witnesses that have testified, all the witnesses that were interviewed, all got together and entered into an agreement to conspire against him. And I'd submit to you that's unlikely. It's not supported by any of the evidence, and that he's trying to pull the strings now with you. He's trying to tug at your heartstrings and make you feel guilty for doing what you have sworn to do. And I would submit to you that it's your responsibility to do what you swore to do. At least someone in this courtroom needs to have done what they've sworn to do. The defendant did not do that. And I would ask, and I would submit to you that we have proven this case beyond a reasonable doubt to you that the defendant is guilty as charged of these crimes, and it's your duty to not let him tug at your heartstrings and feel bad about what you must do. It's not a referendum on him. You are not, as he said, only looking at, in the end, at the failures. What you're doing is looking at the facts and judging those facts for what they are. Things that the defendant did. And what he did was illegal and knowing and felonious. And I would ask you to find the defendant guilty of all of these charges. Thank you.